Hi, this is Daniel Findling with Findling Law and thedivorceguy.com, and we're going to discuss parenting time. I call this the master class in parenting time because we're going to cover everything you need to know. This is a deep dive into parenting time under Michigan law. All right, so what is parenting time? It really defines the frequency and duration that each parent spends with the child. One parent spending every Monday, Tuesday, the other parent Wednesday, Thursday, and maybe you're alternating weekends or a holiday schedule. That's what we mean by parenting time. That's different from custody. Custody really defines major decisions regarding the child, and traditionally we used to use the term custody. It's an archaic term to describe which parent has the majority of parenting time. That isn't used so much anymore. Okay, there are 4 statutes. I call this the 4 statutes of parenting time. 722.27a is the parenting time statute, describes how parenting time is granted. One of the things that 722.27a provides is that parenting time be granted in accordance with the best interests of the children, and that's 722.23. It also has, as we're going to learn further, additional provisions, really under 722.27a7, different factors. MCL 722.27c talks about, and we're going to examine how to modify parenting time, and MCL 552.642 is the make-up parenting time statute. Okay, so for an initial parenting time evaluation under 722.27a, it provides that parenting time shall be granted in accordance with the best interest of the child. That's 722.23, the same best interest factors that we utilized in a custody determination. Subsection 2 of the statute provides that the parties agree on parenting time, the court must order it unless there's clear and convincing evidence that it's not in the best interest of the child to do so. So courts will enforce parenting time agreements. Subparagraph 3 is a general provision that provides that a child has a right to parenting time with both parents. Okay, I talked to you earlier about subsection 7 of the factor. These are the actual parenting time factors. Let's take a look at them. Let's see here. There we have all of them now. Any special circumstances or needs of the child. If the child's autistic, for example, or has special needs, that's something that the court shall take into consideration. If we have a child of tender years that's nursing, every county has their own policies, so to speak, but the statute specifically provides less than 6 months or up to a year and the child's nursing, the court has to take that into consideration. Whether the child may be subject to abuse or neglect during parenting time. What about a parent? Would they be subject to abuse or neglect, maybe in exchanging parenting time? If we have parents living in different areas, the impact of traveling on the child. Will the parent exercise parenting time? Has the parent failed to exercise parenting time in the past? Whether a parent may conceal the child, and any other relevant factors. Now these factors, A through I, are a guideline, with I being the really catch-all provision. The court can consider anything when evaluating parenting time. That is, the frequency and the duration a parent-child spends with each other. It's based upon this statute and these factors. Okay, so we know that parenting time has to be granted in accordance with the best interest of the child. What are these factors? Well, the sum total of the following factors must be considered to be evaluated under the best interest analysis. It's important to note that not all factors are given equal weight. For example, the ability of the parties to foster and encourage a good parent-child relationship may be the most important factor in the case, or the emotional health or the mental and physical health of the parties may be the most important factor. They all have to be considered, but they're not necessarily given equal weight. Because this is parenting time and also crossover with custody, these are the factors. Love, affection, existing emotional ties between the parties involved in the child. How does the child show you love? How do you show the child love? The capacity and disposition of the parties involved to give love and continue the education raising the child. Where's the child going to school? Can the parent get the child to school regularly? To provide the child with food, clothing, and medical care. It's hard to imagine how this would be relevant in parenting time, especially if there's child support. But if a parent frequently fails to take the child to medical appointments, it may be relevant in a parenting time analysis. The next group of factors here, stability of the family unit, factor D and E, permanence of the family unit, the moral fitness of the parties. Is a parent introducing a child to his or her boyfriend or girlfriend, a paramour, may not be considered morally fit, a relevant factor potentially in a parenting time case. Mental and physical health of the parties, the school record of the child, the reasonable preference of the child if the child is of suitable age and discretion to express a preference. It's important to note that a child doesn't make decisions regarding which parent they want to spend time with. Parents make those decisions, and if they can't, a court will. However, if we're talking about a 16 or a 17-year-old and the court recognizes that it doesn't matter what they do, the child is or is not going to exercise parenting time, that's a factor that is often taken into consideration in these cases. The willing of the parties to encourage a close and continuing parent-child relationship. It is the most important factor in a custody case, and it's the most important factor in a parenting time case. What do I mean by that? If parents simply are not getting along, they're talking disparagingly about the other parent, they're prying with the child about what the other parent is doing, it will impact the child's mental and emotional health, and certainly can impact parenting time, as can domestic violence. Once again, we have this catch-all provision. Any other factor the court may be considered relevant. Okay, let's regroup here and recap for just a moment. Parenting time is governed under 722.27a and specifically subsection 7a through I of the statute, which sets forth the parenting time factors. But subsection 1 of the parenting time statute says it also has to be in accordance with the best interest of the child, which is MCL 722.23. So you look at these two statutes together, and the court has to make a determination by the preponderance of the evidence what parenting time should look like on an initial determination. This is how parenting time is decided. What about modifying parenting time? What about parenting time modification? Preparation is key. Why? In order to modify parenting time, we have to look at what has changed since the entry of the last order. This is a threshold determination. 722.27c provides the court with the power to amend its previous judgments or orders regarding custody or parenting time when proper cause is shown or because of change of circumstances since the entry of the last order. Now, when it comes to defining what proper cause or change of circumstances are, we have to look at first what the definitions are provided in case law, because the definitions of proper cause and change of circumstances is not provided in the statute. All right, Vadvarka versus Grassmeyer, that's a seminal case, the most important case defining proper cause or change of circumstance, but it does so in the context of a custody case. And the threshold is really high. In order to establish proper cause to revisit custody since the entry of the last order, a movant, which is the person requesting the change, must show, by more likely than not, evidence of an appropriate ground that should be relevant to one of these best interest factors that we just went over, but here is the key learning here. It must have such magnitude to have a significant effect on the child's well-being. This is such a high threshold that courts will often deny the motion for failing to meet the definition of proper cause. For custody, it's of such magnitude, so large, that if we don't make the change, it's going to significantly impact the child. same holds true for change of circumstances under the definition section as defined in Vadvarka in this custody case. In order to establish a change of circumstance since the entry of the last order, the conditions surrounding custody have a significant effect on the child's well-being. They've materially changed. This really, really high burden, which has come to mean that courts are going to use this threshold, the failure to prove proper cause or change of circumstance, as a basis to deny a change of custody. But we're talking about parenting time here. What does the law provide regarding proper cause or change of circumstances as it relates to parenting time? Is it the same burden as custody? And the answer is no. Under a case called Shade versus Wright, it's a Michigan Court of Appeals case, unlike custody cases, normal life changes are sufficient proper cause or change of circumstance to modify parenting time. Now be careful. If you're trying to go from, let's say, every other weekend to 3 days a week of parenting time, normal life changes is going to get you in the door. You're going to meet the threshold of proper cause or change of circumstance. But if you're trying to go from every other weekend to the majority of parenting time, courts have interpreted this as being a change of custody. So if you're making a change of parenting time that is so large that it can be interpreted as a change of custody, then the higher threshold of material, significant impact on the child's well-being would apply. So for our purposes, a change of custody would mean equal or more parenting time from less than equal parenting time. Otherwise, if you're just trying to tweak parenting time, add a night, subtract a night, without changing who has the majority of parenting time, this lower threshold would most likely apply. Now that's a loose definition of it, but for the most part, it's going to be accurate. If parenting time modification request is actually a change of custody, high threshold. However, the threshold for parenting time is normal life changes. Okay? Once again, that's since the entry of the last order, but what do we mean here? Under Shade versus Wright, just changing school from middle school to high school. Or maybe the child has gotten older. The child has a preference. The child is spending more time at mom or dad's. All of these instances may not be enough to meet the threshold of proper cause or change of circumstances for custody, but would be for parenting time. We covered a lot of ground, so let's talk about it in terms of summary, in terms of parenting time. 722.27a are the parenting time factors. Sub 1, if the parties agree on parenting time, the court's going to order it. Parenting time shall be awarded in what's in the best interest of the minor child. It's presumed to be in the best interest of the minor child that a parent and child have a relationship, a strong and nurturing relationship. Subsection 7 are the parenting time factors that we discussed. MCL 722.23 are the best interest factors, those 12 child custody factors that have to be evaluated because under 722.27a1, parenting time has to be granted also in accordance with the best interest of a child. To modify parenting time, the authority to modify parenting time to amend or modify its previous judgments or orders is found in 722.27c on proper cause or change of circumstance since the entry of the order. The party requesting the change has that burden of proof. It has to be related to one of the 12 best interest factors. And then we distinguish proper cause or change of circumstances, both under Vadvarka and under Shade, where ordinary life changes are sufficient to modify parenting time. However, if the parenting time modification is so great, it may be considered a modification of custody, and you have that significant and material change. This is the threshold. And the reason proper cause or change of circumstance is so important, this is the basis by which a court will say, no, we're not going to proceed. We're not going to have another hearing. All right, so if the threshold is met, If you've met proper cause or change of circumstance, what happens? We return to 722.27a, and you get another opportunity to reevaluate parenting time under the parenting time statute. This is a hearing called the Lombardo hearing, where the court will take evidence regarding both the parenting time factors and the best interest factors. The key, once again, for modification is that a court is not going to modify, not going to change it until you've met that threshold. If and only if you've met the threshold of proper cause and change of circumstance, will you have an evidentiary hearing or an opportunity to argue the parenting time statute and the best interest statute in support of modification. And the fourth statute that we're going to talk about right now is the make-up parenting time statute. That's found in MCL 552.642. It shall be of the same type and duration as the parenting time denied. It shall be taken within 1 year. The person denied parenting time gets to choose the parenting time that's going to be made up, and you must notify the other party within 1 week before making up the parenting time, and within 28 days if it's a holiday or summer parenting time that's being made up. This is a statute that most lawyers don't even understand, but every county has to have a policy that incorporates these 4 provisions regarding make-up parenting time. So if parenting time has been denied, you can file an action, whether it's a show cause or a motion for make-up parenting time under MCL 552.642, and get your client make-up parenting time. Now, this has been a really quick deep dive masterclass into parenting time under Michigan law. It's inevitable that you may have questions. I want to invite you to answer questions, or to ask questions. And if you have questions, you can call me at the number provided on the screen. You can also visit the divorce guy. Email me at daniel@findlinglaw.com. I'm Daniel Findling with Findling Law and thedivorceguy.com. Thank you for the time. Hopefully you found this helpful. We're here to help. Let it be our privilege.